said, his word against hers.
Christopher Melcher is a family law specialist.
Need to get to that point so quickly.
No way in California to keep it secret, and it's a nuclear option. Welcome to Privacy Issues in a Divorce. Today we're going to be talking about something that sounds impossible, which is keeping private a public divorce proceeding. Now, we've handled cases like this before, some that no one's ever heard about because we have done it so quietly. And that takes a lot of intention and thought and care, and also takes a really good working relationship with your opposing counsel. And the ones that we hear about are usually when there's a fight. So we're going to be going through in quite a bit of detail about all the little tips and tricks that we've found to keep a divorce quiet. I'm Chris Melcher. I have a statewide practice on family law at the trial and appellate level. And I'm hoping that we can connect up on LinkedIn if we haven't already.
Likewise, Chris. I'm Tony Storm. Many of you know me. I see a lot of friendly faces that are coming in. I'd like to say hi to Shawnee, Shawnee Brofman, Don Gray, Alicia Wecker. Good to see everybody on here. Zara Elihu, who I haven't spoken to in a while, but I'm glad she's tuning in. I'm also, I was a Walzer Melcher alum for quite some time. Like Chris, I also handle appeals. I mediate cases whenever possible, but sometimes it's not. And when it's not, we're forced to litigate them. What we're going to be talking about today is how to keep these cases private when we can. It takes cooperation. We need to know that everything that we file is public record. So we need to be careful what we include in those filings before we jump in that public stream. Why do we need to be careful? Because leaks cause tragedy. We'll discuss some strategies you can undertake to mitigate your client's dirty laundry from being aired in the public. Now, we have a couple kinds of cases. We know, because we've litigated these, we have contested cases, which are noisy. Contested cases are litigated cases. They're ones where we're filing things all the time and going to court and arguing. Most of our cases, at least most of mine, are uncontested cases. They result in a negotiated settlement, and it can be controlled and is much quieter.
So we have a tension here between this family's right of privacy and need for security about their data and themselves versus the right of the public to know. And so most of the stuff we're going to be talking about today is that tension and finding that right balance because they really can't have all or none. So there's not going to be complete privacy and there's not going to be complete exposure to all this information either.
What we're going to do in this presentation is 1, identify the risks. 2, take protective measures. What can we do to minimize those risks? 3, what can we do to keep things quiet? And 4, when all else fails, how we can fight back. Now, in identifying the risks, we need to be cognizant of what isn't revealed. Think about all the information that you're putting in your pleadings, the personal information, the financial information. Just wait, at least this is my opinion, until all of the information in the LA Superior Court comes online and is public record. Well, it's already public record. I anticipate there's going to be a free-for-all of fraud because there's a treasure trove of information in those pleadings. So,
and what Tony's getting at is that right now it's public record, but it's a little bit harder to get access to some of the LA court files. Eventually, when everything in LA is made available just for easy download, as it is in some other counties, it does place people at risk, particularly children, where this information is so easily obtainable. And so we want to be super, super careful about what we put in there. Now, typically, we're going to have home addresses in the court file when we have children involved, because we have to fill out that UCC JEA form. So we're going to be talking about that. When we have disputes over custody, we may talk about where these children go to school. We may be talking about where the exchange points are. This information sometimes is necessary to advance a case, but I like to put it in very sparingly because it also provides risk to the family. It can go beyond that. In these high-profile families, they have bodyguards and security teams. And in one case that I had last year, some of those security measures were potentially going to be exposed in the case, and that places the family at tremendous risk. And so I would be cautious about that, and not just saying, what the security is and what protective measures are being taken to keep these children from potentially being kidnapped. Because it really places them at more peril. So we're going to have to find other ways of getting that information out there to the extent that it's relevant to the case, and it could be. And we're going to talk about things like that. There could be undisclosed facts. Sometimes people's health conditions are in there in the court file. Do we really need that? Is it absolutely necessary? Is there another way to do that? There's embarrassing facts, sexting, photos, stuff like that, I'd find up in a declaration. And do we really need to do that? And can we do it, if we have to present it, can we do it in a way that's not public?
So we all know we have a lot of financial information in our pleadings. We have income and expense declarations. How often is there testimony about somebody's earnings? What do you personally list on a party's income and expense declaration? The property in their judgments, the values, if you list that in the judgments, who they bank with, those last 4 digits of their bank account numbers. Are there any business secrets or trade secrets? So, for example, if one of the parties is negotiating a sale of their corporation, or even selling their family residence, publishing something as simple as a sale price could impact those negotiations, especially if there's receivership involved. Perhaps I've seen family law auctions where houses have been auctioned in the family law court. And if the prices are known and public record, it really can have a adverse impact on the parties.
And we're also going to be talking about dealing with executives, because it's not just celebrities that have these concerns. It's executives, founders. And so at the end, towards the end of the program, we're going to be talking about ways to protect this need for the company to keep its secrets versus the need to disclose information. And that's where we get into material non-public information.
You need to balance the duty to disclose under the family code with, for example, the duties somebody might have to the SEC to keep a secret. So why does this all matter? Like we addressed at a high level, you could be putting your clients at risk. They could have their children be kidnapped if they know the exchange points. There could be extortion, assault, identity theft from scammers. You need to keep cognizant of the physical security of your clients and your children. Chris brought up the UCCJA earlier. I, in cases, have just wrote private and included a zip code and see if it passes. And I've had success doing that. So we've seen the incidents of people targeting schools via cyber attacks tripling from 2018 to 2019. We don't have 2019 to 2020 numbers yet, but I expect they're going to go up. I know in the UK, there was a report that it said there's an 83% increase in cybersecurity cybersecurity incidents at schools. The parties may have a blind trust, and disclosing where they live will put a star on that star map. So be careful what you do.
And right now we're just going through what the risks are which are pretty obvious, putting stuff in a court file, and then soon we're going to get into what we can do about it. But it's not just the physical security risk. It's also dealing with the damage that could be done to the brand and the person's image. And we see this, unfortunately, in so many of our cases where the parties are trashing each other in these declarations and hearings. And, I understand maybe that just goes with the territory in our work, but it has long-lasting effects, and it can really end up hurting both sides by doing that. So we'd be very, very cautious about it. And that's why many celebrity couples will do these messages that they'll have a long negotiation, very, very quiet. And then the only time that you've heard that they've broken up is when they have a press release about how they're going to be friends going forward. We have to be concerned about their contractual obligations. So there may be a requirement that they not reveal information about books or plots, movies that they're working on, that they not be held in ill repute. Even if it's not a violation of a contract, what they're doing could cause a show to get canceled. There's Marion Stanton sent in a question, and please feel free to send any Q&A down there, and we'll be taking a look at it. But what about everything that's already out there? Well, for sure, some of these people have lots and lots of baggage already. Our concern is really for the children, and if they have any, and they're going through a divorce, and just so we're not revealing where they live and where they're going to be exchanged and which parent has them at what particular time, because that's going to be some powerful information for paparazzi or for people who are stalking them.
Yeah, if it's out there, it's hard to unring the bell, quite frankly. It's in the public record. Having something pulled from the public record is going to be extremely hard to do, I think. So how do you keep things quiet, Chris? One thing we can do, we can file under a pseudonym. We've seen this a lot. We just don't think about it. Roe v. Wade are not the parties' names. It's a pseudonym. But if you're gonna file under a pseudonym, like here we have JD v. MD, which we see always in parentage cases, or John Doe v. Mary Doe, I would follow up with the court and file an RFO, lodge the information requesting leave on why a pseudonym is required. You can include the same leave on item 11C in the petition. I would lodge the facts and circumstances that show an overriding interest, why it's in the best interest of the parties and the children, and that there would be a significant prejudice to the parties absent filing as a pseudonym. And most important, it's the least restrictive means the court can employ to protect those interests. Although the statute is for guardianships, if you're going to file under a pseudonym, check out CCP 372.5, because you'll find it very instructive on what you can do.
And so what I've been doing, and just my style, is just file it and see what you can get away with, because not all the clerks are looking at these things as carefully as others. And so they may just process it. And so I'm just trying to put in there the initials, hey, and see what happens. And we're talking about a divorce case. And see what happens. If it flies through, great. We'll let the judge know later on who the parties are. But at least to get the thing filed, sometimes I'm trying that, and sometimes it works.
Chris, I've never actually seen a petition kicked, but I have, it's possible when you have an RFO, the judge will say, this isn't a parentage case. Why is it, JD v. MD? So, and you can answer at that point in time. And note the CCP 372.5 factors.
And the reason why I've been thinking about this is because of the appellate work that I'm doing. Is we see in the custody cases that we can anonymize those, and now we're wind up with all of these initial cases, which are very hard for me to remember, but it's all this alphabet soup of case names that we have now, because those are not necessarily paternity actions. They can be dissolution actions where they went up on appeal and the only issue is custody. Maybe an evaluation is involved, and we can ask the Court of Appeal to anonymize. So if we can do that at the appellate level, we can do it at the trial level. And for me, I just think like, hey, let's see what we can do to provide some privacy to our clients, because we don't want all of this being leaked there if it's a high profile party. So now that we've filed and we do have to put stuff in court documents, what do? Well, we have the UCC JEA form, like Tony mentioned. It's calling for home addresses, current for the children. We honestly don't need that unless there's going to be a jurisdictional dispute. If both parties live in California and no one's going to contest jurisdiction, it's meaningless information, really. And so we can just put in there private in the zip code. And hey, if somebody's going to challenge it later, then we can give the full info, but why just throw it out there blindly?
I only had one UCJA form kicked for writing private, and I resolved it by just putting in the zip code. The only reason it was kicked is they wanted to know it could be filed in the county.
So the other thing is, marking documents as confidential, closing the courtroom. We're going to be talking about that, later. But the thing is that if we do have to file something, we want to do our best as possible to keep it quiet and to control that information, whether it's through trying to file it under seal, which is very hard, doing a redacted, an unfiled version, a lodged exhibit, something like that. We're going to get into some of that, but maybe just identify it without disclosing the contents is what I'm trying to get at there with that point. The final point, and this is the most important one, is coordinating with opposing counsel. We don't always have that relationship, unfortunately, but when we do, it's gold. And it helps both parties when they're able to at least agree that certain information doesn't belong in the court file. Sometimes you'll have opposing counsel who wants that information out there, and it's a way of really punishing the other side and making them want to settle. Nothing you can do really about that one. But when we do have cooperation, let's use it. The other thing, like I mentioned at the beginning, was you settle first, then you file later. So basically you're doing everything you can to get the case done, and everything's basically signed and ready to go. The last step is really filing it and having a judgment entered, which is confidential. And by the way, if anybody needs that form, I do have a basically a template to have a judgment entered without attaching the MSA or stipulation for judgment. All those details are confidential. They're not made part of the judgment or no orders on them, but they are confidential. The other issue or way I've seen people is doing is filing it out of county. Michael Douglas had a divorce and years back and had it filed in Santa Barbara County, where I suppose he had a home. And so that made it a little bit harder for folks to find it because everyone was probably thinking Los Angeles.
So mediation, we all have heard everything that happens in mediation stays in mediation, and that is pretty sacrosanct. There is no such thing as a mediation privilege, however. It's a common misnomer and people use the wrong word. Mediation confidentiality is a doctrine. A privilege, on the other hand, can be waived. A doctrine cannot. So it's important to think, when does it end? Obviously, when you have a settlement agreement, but keep in mind, 1125A5 set of the evidence code, if there's no signed writing or a settlement, then 10 days has to pass when there's been no communication with the mediator regarding the dispute.
And so I've had to litigate this one before, because sometimes you're in a mediation, you're exchanging offers and documents and reports, and there's no settlement at the mediation session, and then afterwards you continue exchanging some information, thinking that you're in mediation, and then somebody wants to use one of those documents, and that's what I had a whole trial about, is whether that document was admissible or not. And it would have made a big difference if it was. And so we get into this 10 days of silence. If you haven't communicated with the mediator in 10 days, then the mediation is terminated. But things that are done within the 10-day period are within the mediation. So it's good to look through that, mechanically understand that. to be very clear to say, hey, I walked out of that room and mediation is off, or I'm still in mediation mode. And so we know that our documents are going to be protected. Now, one thing that that came into law a few years ago is this mediation disclosure statement. And so in Evidence Code 1129, there's a form that we need to use to have our clients sign before we go into mediation. And so it's this big long thing, and it explains everything that they need to know. But I don't see the mediation providers, unfortunately, doing that. I really think, and I've talked to some folks at JAMS and so forth, but I really think that they should be doing this every mediation, because a lot of the attorneys aren't doing it. We're required to do it, and I'll explain in a second why. But the reason how we control over this is we have the retainer agreement that, of course, we have everyone sign. We also have them sign the mediation disclosure statement right when we sign up a client. It has to be a separate document. We have a checklist, and we make sure that they've signed that, so at least that's done with. The reason why this came up is they tried to do away with mediation confidentiality with respect to lawsuits for malpractice by a client against an attorney relating to a mediated settlement. And the case law says you basically can't sue the lawyer for malpractice for a mediated settlement, because everything that the lawyer would need to defend himself or herself would be confidential and unusable. So to get around that, they looked at creating exceptions that didn't go anywhere. So they then settled on requiring this disclosure statement. 1129 says that there's no set aside for failure to get it. But then the question is, could we be disciplined if we haven't obtained it? So I think it's super important. The language that you need is right there in 1129E, and I would just encourage you to have all your clients sign that all the time.
So the local court has the authority to close the courtroom when it's appropriate. Say, for example, you have a high-profile case. You recognize a reporter, maybe a blogger, a possible third-party witness, some other interested party, maybe an investigator, and you see a need that it's in the best interest for the parties or the children to close the courtroom. Family Code 214 says the court may, when it considers it necessary and in the interest of justice, and the persons involved, direct the trial of any issue of fact joined in a proceeding under this code to be private. And in doing so, it could exclude all persons except, obviously, officers of the court, the parties, witnesses, and the attorneys.
So I'm utilizing this. Obviously, if it's a paternity case, you have a leg up and you can just ask, hey, close the courtroom. But if you're going to have a child custody evaluator testify, you have some really sensitive testimony happening, particularly around children. Even in a divorce case, I would say I want the courtroom closed. No 214 as the authority to do that. So even though it's a public court proceeding, there are times when the courtroom can be closed. And again, it's just a balancing of the public's right to be in there and monitor that versus not. And if we're doing a virtual hearing, most of the time that's going to be streamed. And so closing the courtroom would be stopping the stream. So all the other participants there would be watching, but the stream would be stopped. And so I encourage you to utilize that, at least ask the court for that. Now,
I'm sorry, Chris. If you don't ask, you don't get. So there's never a harm in asking. There's only a harm in forgetting to ask. So
in parentage actions, we've looked at those as being closed proceedings, and courts have gone along with that. And that's Family Code 7643. But there is a bill pending right now in the legislature. It's AB 2745 to repeal that statute. And so the history there under parentage is that these were thought to be embarrassing or shameful, that to have children out of wedlock or whatever. And so these were secret proceedings. And so this new bill says, well, that's not the case anymore, so we don't need the law. I'm opposed to this statute because I think all custody proceedings should be treated the same. Whether it's happening in a divorce or a parentage action is irrelevant to me, and it's irrelevant to the children that are involved. They should all be treated as closed proceedings in my mind. So I'm opposed to that, but there's a lot of tailwind behind that bill, and my guess is it'll probably pass. If you don't like it, write to the legislature. You can look up AB 2745. I think it's going to the Senate Judiciary Committee now, and write a letter.
I think there's also an issue on that bill with retroactivity. So what happens to all the parentage actions who they thought they were confidential and assumed everything would be private, and now it opens up? So it's a whole other discussion. But what we want to do in these cases is limit the records that are going to be in limit the sensitive information that's going to be in the public record. You can redact it. You can bring an unredacted copy to the hearing. If the court wants to review it, you can request they do so in camera. So another thing you can do if you have cooperative opposing counsel is to exchange the unfiled declarations so they can see it and make their argument to the court. We'll review later in this program, but one thing I've seen used effectively when you have cooperative opposing counsel is scripting the hearing. We'll get to that in a little bit, but
so on this unfiled declaration thing, I know it's totally unusual, but again, these are unusual cases where you have one or two really high profile people involved and you're trying to keep it super quiet, but you're also not agreeing on everything. So what could happen is you say, okay, we have a hearing in September. And so I'm going to have my declaration sent to you by X date, whatever, 16 court days, and you're going to have your declaration sent to me by 9 court days. And at least that way we know what each other's positions are, what the evidence is, what the testimony will be, but we're not going to file them. And so we've given notice to each other, but we haven't given it to the court. Now the court's obviously in the dark. But we're hoping that we're going to be able to resolve it before the hearing. If we get to the hearing, then we can move those into evidence, and the court may not be too happy about that and may continue it because it hasn't had a time to look at anything. But again, I'm just trying to be creative here and looking at ways that we can actually litigate a case quietly rather than noisily.
So one thing we can try to do is seal a document. It's a pretty difficult and onerous thing to be able to do. The court, as we've said a bunch of times, they balance transparency with the public interest. I think it was Justice Brandeis that said sunshine is the best disinfectant, and generally the court follows that. Code of Civil Procedure 124 mandates that every court shall be public. There's a lot of case law, Richmond newspapers versus Virginia, about the right of press to follow judicial proceedings. We had a marriage of Lechowick. I don't know if I'm pronouncing it right, Chris. Lechowick, but anyways, however it's pronounced. In that case, a judge was trying to get divorced, and they denied a journalist's motion to open the divorce of a bench officer. First District reversed the case. They said they need to show a particularized need by the moving party. The most well-known case is NBC Subsidiaries versus Superior Court. It was the Clint Eastwood case. It was a jury trial. The press and the public were excluded. The transcripts were sealed. NBC filed a writ. Long story short, it was affirmed by the California Supreme Court. So the public has access. Public access serves to demonstrate that justice is meted out fairly, thereby promoting public confidence in such governmental proceedings. It provides a means by which the citizens can scrutinize and check the use and possible abuse of judicial power and enhance the truth-finding function of the proceedings. We know the First Amendment prevents closures. We have Code of Civil Procedure 2550 to file under seal, but there is an overriding interest, like we said, in balancing a public interest to support the sealing and a substantial probability of prejudice if the information isn't sealed. So if you're going to get an order to seal, it needs to be narrowly tailored, and there needs to be no less restrictive means necessary to achieve that goal.
And it's nearly, it's so difficult to meet that standard. And so what I've seen people do is just go ahead and just file things or lodge things conditionally under seal. I've even seen courts grant sealing orders. But I had one case last year where the supervising judge directed, apparently, the judge that granted the sealing order to undo it. This was in another county outside of where I usually practice in, but they said, no, you're not doing this. So sometimes we'll be able to get away with some sealings, but when you actually go through Rule 2.550, it is onerous. It is very, very difficult to meet that standard. And so, you know, like I say, because the public right to know stuff, and we're going to work through a couple examples of things where people have tried and failed. So it's no joke. I mean, it's not just putting words on a page and filing a motion and getting it rubber stamped. There is some oversight here functioned by the court to make sure that it's not improperly putting stuff out of the public reach. So this is our absolute last resort, I would say, to be relying on sealing things, because I believe it's almost impossible to have things sealed. Now, if you do want to go that route, you have to file a motion to seal. Now, what happens if you are in possession of documents that are subject to a confidentiality agreement or a protective order, and you want to use them in your case, and the other side is the one who really needs to do something about it? You're not wanting to protect the confidentiality of this, but you feel bound by the agreement or order. What do you do? So fortunately, the rules have a process for that. In 2.551, it says if you have a document that you've obtained in discovery that's subject to a confidentiality agreement or a protective order, and you don't plan to file a motion to seal it, and you want to use it in your case, you then would lodge it, and you would give notice to the other side of what you're doing. That then triggers 10-day period for them to do something about it. And so it puts the onus on the side that wants to keep it protected to actually go in, file the motion, make the showing under Rule 2.550 if they can. And then it would either be sealed, partially sealed, whatever it's going to be. Art Grader, you had a comment here about redactions. We want to be super careful about that. I think printing something with a Sharpie and scanning it, a lot of times we can see right through that. You know, I'm using Adobe Acrobat Pro. It has a search and redact tool. So if you haven't used it already, but it's pretty easy, you can just search for things like Social Security numbers, and it'll find them for you and help you redact it. But if we're going to redact it, we want to make sure it's actually redacted and can't be unredacted.
So sealing of disclosures. On the books, we have Family Code 2024.6, which most of us know as the Burkle statute. It's still on the books. It's not good law. I think Roy Paul was the judge in that case. You know, 2024.6 essentially says, you know, if there's going to be financial assets and liabilities in a pleading, they're automatically sealed, if I'm not mistaken. So it's unconstitutional. It's unconstitutional. The Associated Press and the LA Times intervened in that suit, and it's no longer good law. Should be probably cleaned up in the Family Code, but it's still there. Shouldn't be followed.
And it's an important lesson, because you look at the power, which is pretty amazing, of Ron Burkle, multi-billionaire, going through a divorce, not wanting his information to be public, which is totally understandable. There's all of a sudden now this statute created to assist him, and but it doesn't withstand court scrutiny. So if he can't do it, I think we have a hard time doing it. And it just goes to show, really none of these financial issues are going to be sealed unless it's a trade secret, material non-public information regarding a company. that's public or going public, something like that. On the financial side, I think it'd be very, very hard sell to get anything sealed. Now, what about children? We all know we typically have in our judgments and agreements non-disparagement provisions, that there'll be no disparaging remarks by either parent in front of the child, or we won't even allow a third party to do that. It's typically in these things. Well, look at Melissa Gilbert. She's going through a divorce. Her ex-husband had threatened to make disparaging comments. I think they were hateful speech, I think the case refers to, that certainly would have harmed their child. And so there's an order prohibiting them from doing that. It makes perfect sense, but not in light of the First Amendment. So here we have Melissa Gilbert, who can't get an order stopping her ex-husband from making public statements that would be harmful to their child. We have Ron Burkle, who can't stop financial information from being disclosed publicly. So that's why I say these are last resorts. If we're getting down to gag orders and motions to seal, we've lost the fight. We've got to win it beforehand through cooperation with counsel and using a lot of common sense about what we're actually going to put in this court file.
And when you have cooperative opposing counsel, but a public hearing can't be avoided, something like a guardianship action, for example, you might consider scripting out your hearing with the opposing counsel, request a chambers conference when you do that, or a call with the judge beforehand. Let them know, we're going to have the press there. There's going to be people watching this celebrity thing. This is how we intend to proceed. I have a feeling a judge will really like to see two attorneys that have pretty much worked everything out, but they need an order. So if you have your chambers conference or phone call with the judge and it's been scripted, my experience is the judge will give you some direction and have some comments in that conference on what's going to happen at that hearing. So it's in the interest, sometimes it's in the interest of that public figure to create the narrative. Maybe in the scripting, you might represent the party who has the claim, but maybe to create the narrative, the other side files the action because the other side may be the public figure and they want to tell their story their way. And it really doesn't matter how it comes out to you, but it might to them. So compromise is key. Now, we use temporary judges all the time. It's still a public proceeding. Oftentimes we just submit our pleadings to the judge directly and we don't file them. That's not the way it's supposed to happen. All family law proceedings, property, support, custody, it can be tried before a privately compensated temporary judge until a final determination of the cause of action. That's in the California Constitution. That's in a case called Saracino v. Superior Court. If anybody wants the cites, I'm happy to send them to them. But having a temporary judge can be convenient, especially now when I've seen hearings being scheduled out as far as February 2021. So if you have a private judge, they can accommodate the schedule that you need. You can have your consecutive days, but all original pleadings must still be filed with the court. They need to be bait stamped. Well, they don't need to be bait stamped, but I find in my practice it's helpful to have them bait stamped. So excuse me, I strike that. But the copies need to be conformed and provided to the private judge. There's a California rule of court and a local rule here in LA. The rule of court is 2.400 and the local rule is 2.24 subdivision 1 that says that they all need to be filed. Not only do we need to file them, if we don't, the private judge has to comply with 2.400, so they need to make sure that we're doing our job.
And I'm trying to get the private judge words out of my head and just temporary judge, because I think a lot of people have abused this privilege that we have of being able to have these privately compensated temporary judges and treating them so private. And everything is supposed to be filed before the judge sees it. And so and obviously that's going to ruin a lot of confidentiality. I've seen some judges not observe that rule and take pleadings and even make orders without it being filed with the court. And I don't think that's in compliance with the rules, but you know, you may want to, I guess, if you're interviewing a temporary judge and see what their practice is, if you had a super high profile case, and there's some that are willing to do it differently, but others will comply, and everything ends up getting filed. I would give the Brad Pitt case as an example. I don't know how many of those court documents are actually made it into the LA Superior Court file. I actually looked up the case number one time and it wasn't even findable for some reason.
Sorry.
Now,
I mean,
go for it.
no, I was going to say the dates, times, and places of these trials need to be published. So anybody has the right to attend. Arguably, it should be streamed online unless you've got an order to seal the courtroom. So go ahead, Chris.
So this brings me now to contractual arbitration. So this is an area that I've looked into for a couple cases that were super, super high profile that we could not take any chances on at all. We weren't going to go, you know, trust that the private judge would keep everything secret because they can't. And we weren't going to trust that things were going to be sealed because it can't. And so, but they also couldn't agree on anything. And so we looked at this contractual arbitration model, and it's super interesting. And I know when I first started doing it, it was like, you can't do that. Everyone I talked to, you can't do that. And sure, there's some cases that talk about maybe you can't, but I'm not convinced. And so I think that there is a pathway for this well beyond this program, and I have research on it. So if you're looking at it, let me know. Happy to share with you what I found. But basically, there are some cases, Woolsey and Assimi, that talk about the arbitration not being suitable for child support or child custody matters. Well, let's just put those aside for a second. But that could mean then everything else. What about spouse support, property division? Who cares about that? There's no gigantic public concerns there. Why can't we arbitrate that? I say we can. And now as to child support and custody, the problem that they had in those cases were more about the process. And in a traditional contractual arbitration, the rules of evidence don't apply. The court doesn't necessarily even have to use California law. And there's no right of appeal, and there's very limited discovery. Now, obviously, that's not going to work for a big issue like child support and child custody, where the state is in almost a parental role overseeing and making sure that these kids are protected. But we can build into our arbitration agreement all the rights and procedures that we want. There's case law that says we can do that. We can give a right of appeal. We can mandate that the arbitrator follow California law. We can have full rights of discovery. So with those protections in place, I think we can do it. So I believe there is a pathway to do it. So if you had a case where they don't agree and it's super, super high profile, you can't take a risk of it getting out there, and you want some process to resolve it, look at contractual arbitration. Go for it.
Oh, no, I was just going to interject. Recently, I had an interesting case where we had a hybrid mediation arbitration where opposing counsel was terrific. We were very cooperative. The information from the clients could not get into the public stream. Otherwise, there was significant risk to them. So we said, I don't remember the time frame. I said, we're going to give mediation a shot. We're going to give it 5 hours. If after that period of time, we're not successful, we're going to waive the neutrality of the mediator. And they are going to be able to consider all the evidence presented at the mediation, which was unusual. And they can issue a binding decision. We're going to submit. So it incentivized the parties themselves to come to an agreement, put everything on the table, and it was a gamble. There was really some risk, but it worked out quite effectively because they knew one way or another, at the end of the day, they would have an agreement or actually an arbitration award that would stay private. Sorry for interrupting, Chris.
No. And so with an arbitration, this is all creature of contract. So it's a contractual dispute resolution process. And so the arbitrator is given the power to make a binding agreement, a binding award between the parties by the agreement of the parties in their agreement to arbitrate. So this is all done privately. It's done in private property, so we can exclude the public. That's why there's no right of access. Nothing in the arbitration proceeding is filed in court because it's not a court proceeding. And so the only thing that would come out of this would be either a motion to compel arbitration if they agreed previously and they won't go forward now. And then at the end, the award of the arbitrator. And the award itself could be pretty sanitized and just talk about dollars or particular custody schedule or something like that.
Right. So, the arbitration has some advantages. There are some things we need to be careful of the right to appeal, but, they're not public. There's no notice that needs to be posted. Nobody has an open right to be there. It's not public under, I think, CCP 124, but arbitration decisions are enforceable under CCP 664.6. Now we have different types of arbitration. We have that hybrid that I just talked about a minute ago. We have the standard bread and butter arbitration that we've all done and we know about. There's no, we contract to what rules we're going to apply, and the arbitrator makes its award at the end. Baseball arbitration is something I find all family law attorneys know about. In Major League Baseball, if team owners can't agree on a player's compensation, then each party submits an offer to the final decision maker, and they pick one. They can't split the baby. They can't say, okay, I'm gonna, take this and, divide it in half. It's one or the other, and it keeps people reasonable and honest. You can, however, contract after the bids are submitted, have a final opportunity to meet and confer before the arbitrator issues an award. I like baseball arbitration a lot. I've done it. And I think having that final, after you've seen the other person's offer, the final opportunity to spend, maybe it's 15 minutes before the arbitrator actually renders its award to try to come to some compromise, is a good proactive measure, because if one party is particularly unreasonable, you have some leverage.
And we'll have to keep moving forward here.
So there's protective measures we can take. We're all in this virtual environment now. We have virtual hearings, we have video conference, and we need to understand how to secure them. This is an entire topic that we can have an entire separate CLE on, but the most essential thing to know is we are the weakest link. Most problems are done by human error. Don't screen share things you don't want the other side to see. Close your distracting notifications that are going to pop up on your screen. I know some of you might have heard I'm guilty of this too. I've gotten text messages in this very presentation, so you might have heard the ding come in. I've closed that, so it stops. But luckily, it's not my screen, Chris. We're only as secure as our weakest link. You got to be aware of tricks that people pose, social engineering. Hackers will almost always be one step ahead of you in finding the exploits that are available, like we've seen Zoom bombing. You need to keep your internal system secure. You need to keep we have a duty to preserve confidentiality. We have to anticipate the problems before they occur. You need to watch out for things like fake video conference links from spoofed addresses. If you can, use multi-factor authentication. Need to have malware on your computers to find those keyloggers. I'll let you continue, Chris. I know we're.
Yeah. So the thing, and I'm actually going to go back to this slide for a second, is because it's so important. Basically, this whole context of this conversation we're having here is representing a high profile client. And we now become the targets of paparazzi and other people who want information or intelligence about our client, because we are the repository of every fact of their life, at least it's relevant to this divorce case, which is huge. And so lawyers have found themselves to be victims of hacking attempts constantly. So we have a duty to maintain client confidence, as we all know that, but that includes obviously our data security. So we're anticipating problems when thinking about how is somebody going to hack in and get into my server, get into my office, get information, fool us into revealing information. So one thing that we do is when we have a high profile client, we use a fake name for them. And so if somebody does get our client list or get into the client, into our client's server, at least they can't just scroll down there and find it immediately. Now, maybe they're going to try and copy our whole drive or something like that, but and get it later. But at least if they somehow got access, they wouldn't just find it because it's a fake name. Also, the same thing for meetings when we used to have those, but phone calls, we still do those type of things. We're usually going to have a fake name for the person when they call in. What we're doing is limiting what personnel in the office can have access to this information. So basically, permissions, file permissions. So there's only some people in the office that can actually get into that folder. And then there's certain documents within that folder that are super, super complex, that are, confidential, that are password protected, that maybe me or somebody else has the password to. We want to warn staff about being fooled, because we don't want to say, hey, it's Britney Spears calling and wants to talk to you about your case. And all of a sudden now you think you're talking to your client, Britney, and you're revealing what's going to happen at the next hearing. Wouldn't that suck?
Yeah, it's privileged. Data security, it's great to ensure that you're protected. There's a lot of tools out there that we can use. Some people use Amazon Web Services, which is a great tool to ensure that your protection is off-site, your data is well managed. It provides multi-layer backups. They have servers in different locations. So, for example, if there's a absolute catastrophe in California, your data will still be backed up on a server somewhere else in the country. You want to be wary, though, of having your data go out of the country where the law is different. For example, Europe or China. I had one very high profile case. A client was a tech guy, and he made me aware that certain corporations for file sharing had servers overseas, namely China. And he had trade secrets and certain information, and he wanted to make sure that did not go over the web on these Chinese servers. So Europe has taken security to the next level, in my opinion. So if you have a deposition in France, you may not be able to get your data if you don't bring it with you. So there's a European Convention 108. It's the first international instrument that was used to protect individuals against abuses that accompany the collection and processing of data and regulates the flow of information. It enshrines a person's right to know what information is being stored about them, but also having it corrected. Where we have a opt-out system, where we're often put on lists, they have an opt-in system, for example. So you're not going to get junk mail unless you've opted in for the junk mail. There are also, more importantly for us, restrictions on transborder flows of information. So if you have your deposition in Europe, for instance, don't count that you will be able to readily access your data that you're storing here in California. Also worry about domain name system hijacking, which is basically copying your website. Some third party can copy your website. Some people use the file sharing options are available with many third parties where your client can see exactly what's in your case. A lot of firms accept payment on their website. Well, if somebody has copied your website, they're going to take your payments. Make sure you use anti-malware software. Use two-factor authentication where available. Virtual private networks are essential. Encrypt your email. And I know I'm going fast because we're limited on time, but system like Proofpoint for encrypting emails, it's very simple to use. You just put in brackets in the subject, encrypt, and then your email is encrypted, your attachments are encrypted. Use secure passwords. Really what we want to try to do is anticipate problems and control them before they happen. We're all working at home now, and common sense is key.
So lot of stuff there, and sorry, we're just breezing by it, but Tony knows a lot about security, so you can always talk with him offline about it. One thing I did want to touch on was, because some of these individuals may be, again, executives, founders and companies, they're publicly traded stock involved, and there is a risk for the lawyers who are handling the case or staff to think like, wow, okay, I just learned that something important is going to happen with this company. I want to trade on that and make a bunch of money. Well, that's illegal. And we, as managers of our firm, also need to have a policy to make sure that our personnel does not engage in that conduct, or else we can be personally responsible for that also. So I'm just kind of warning everyone, like, in my office, when I have one of those cases, like, hey, okay, you may have heard that. Don't go and buy that stock, please. We can't do that. I'm going to do anything. Now, Rule 10b5-1 does have and this is an SEC rule, that allows for people that have publicly traded stock, that are officers, directors, big shareholders, to engage in trades without getting into trouble. And basically, it's a plan to sell in the future a designated amount, or to place the decision-making over the sale to a third party, and that insulates them. So I'm building that language into my judgments. If I have an executive who has to sell stock or is being transferred to somebody else and they're going to sell, I don't want the insider trading risk coming back. So I have 10b5 language if you need it. Again, we're going to flip through this really quick because we're running low on time, but obviously we're going to protect the brand and maybe have a spokesperson involved, think about who's going to court. And again, sorry, Tony, I'm flipping through your stuff.
Okay.
Here you go. Go hit the NDA one.
Yeah. If you can get a confidentiality agreement and a non-disparagement agreement. I mean, people have their First Amendment rights and their freedom of speech, but it helps to have it if you can. Put a penalty clause in your settlement agreement if you can do that, where if they do divulge certain information, there's an incentive, they're penalized. So there's an incentive for them not to do it. Go ahead, Chris. I know we're...
Well, this is an important one. And so this MG, it's an unpublished case. It's Mel Gibson. And Tony, I think you know the how to pronounce the lady's name, but I don't. But they had a settlement agreement. They had some litigation, some DV issues. They made an agreement. And part of that agreement was not to talk about it for a period of time. It was 2 or 3 years that she wouldn't disparage him. And then there was some payments in the back end if she complied. And then she went on to Howard Stern's show, made some statements that Mel thought were in violation of that, withheld that other payment. They litigated over that, and in this unpublished decision said, we are okay. The Court of Appeal is okay with that decision. With that agreement, and that penalty is enforceable. And I believe it's in a footnote noted that the First Amendment rights can be waived by contract, which I thought was pretty cool, because I guess if you can waive your Fifth Amendment rights, you can waive your First Amendment rights. So these things can work. There's a live example of it. But the only reason why it worked is because the payment was scheduled for after compliance of the non-disparagement period. Now, paparazzi, there is this anti-paparazzi statute, which is pretty cool, which I also think is constitutional. That's Civil Code 1708.8. So if you had a client who had their privacy violated by maybe a drone flying over and taking pictures in the backyard, like what happened to Prince Harry, I think recently, that's actionable. Now, how you can prove who was it that took the photo, I don't know that part too well, but there is a statute that you can go after them, or they could go after them for to get some recourse. Now, running out of time. This was the 4th webinar that my firm has put on. And we did that because we have now the ability to apply for multi-activity provider status with the bar, which means that instead of getting pre-approval to issue these MCLE credits that we've been giving for these programs, once we get this approval, then we can issue we can just put on programs whenever we want without pre-approval and issue credit to you for that. So the poor sad little cat looking out is us for a while. We're going to take a break for maybe a month or so while I'm waiting for that approval, also get my regular work done and batch some more programs so I can get another list of these going every week. I'll send them out to you. We're going to have some co-speakers. Some of you contacted me. If others want to co-speak with me, just let me know and we'll see if we can put something together. I really love the, bringing all these thoughts together, the comments, the sharing of information has just been incredible. A last pitch for some Google reviews. I know a lot of you have done that and it's really appreciative. Peter and I were looking at this stuff and it's just like, it makes it all worthwhile and it really does help us out a lot. So if you haven't given us a Google review for Walzer Melcher, the link is there that we're gonna be sending out for tomorrow after the program as a reminder. If you could do that, I really, really appreciate it. And I also want to thank Tony so much for helping me put this program on. We've done it, got iterations of it before, and we've worked well together in the past, and I hope to work more again in the future. So in conclusion, how do we keep a public case private? Well, we have to be good risk managers. We have to understand what information is in the court file and try and limit what's out there. Once we see the risk, we can minimize it. Then we can act to protect the client, not only from the information that goes into the court file, but the information that's sitting there in our server. Again, I hope you found some use out of this program, and I will see you at the next one. Thanks.
Thank you, Chris. Thank you, everybody, for attending.